We are 86%, other 45. He's been running this restaurant from then. He took it over. Now, my lords, the trial court 9 for appointment of a receiver.
The trial court appointed you, the first petitioner.
And with various safeguards. What happens is, at the first stage, a learned district judge is appointed as a receiver, and it closes down under him. He says, I can't do it, and it closes down in October. We move and say, please reappoint, continue as the trial court said. Now, the court has appointed an IRP, my lords, company.
14% share. Why don't you do this? Look, ultimately, we can treat this as any other matter and say interim order and this and that. Ultimately, the restaurant has acquired a degree of goodwill, I presume. Why don't you both sit down and one person buys out the other?
We are ready to do so, my lords.
You buy them out or they buy you out.
In fact, it has a provision for retirement also. While it says it's at will, it also says for retirement.
When is this? High Court has appointed, we are not going on into whether we should interfere. If the matter opens, we'll see what to do. But if it continues in the hand, he will not be able to run a restaurant.
He's already said so, Mullers.
And he's now High Court saying, I'm unable to run it. Says I remain closed now for a month.
Take the IRP to mix. So
there is
the restaurant just go under.
My lord, that there is a secret to be known only to the family. My lord, is not a fact. I must bring
absolutely the trial which only the family knows.
Both sides are people of business. You are men of. You want to save the restaurant, right? The restaurant has a goodwill. The hands of somebody who doesn't know what running a restaurant is will come to the restaurant. Why don't you both tell a reasonable solution? Both of you tell us.
That's all I'm saying is whatever safeguards they want to protect their interests. My lords, whatever.
We don't want to take sides. Because if you have to decide it, we'll decide it in accordance with law and see whether we. But why don't you both tell us what the solution should be? Sit down, find a solution.
My lords, she's never been in the business, but surely 14%.
What is your interest? How many people are
four.
Four of them.
Four of us have 80. She has 14. She's never been involved in. Sister, related. My lord,
You four are brothers. So you're all brothers, sisters.
We have one sister is on my side. We are 4 siblings.
Oh, so 3 brothers and 1 sister.
One sister. And her 14% out because she's not been involved in the business. We said, let's value it. She lives in Bangalore. She lives in Bangalore. We offered her 12.5 crores.
You like to go to an arbitration, resolve this.
But in fact, this is
to do that, but meantime, we want to run, my lord.
I know. 9. Been appointed?
No, not at all.
Yes, no. What happened was 86% wanted dissolution first. Suggest 3 names of an arbitrator. As a sister, I consent to the nomination. The arbitrator appointed. Before the arbitrator, my lord, pay the sister 1 lakh rupees per month. They don't come. Lordship, just can be 1 minute. Justice Kodandram has his lordship earlier appointed. Suggested by them. But I must tell you, lordships, a few more facts. Award only 1 lakh per month to be paid to me. They don't pay for 5 months. I file an application for receiver before ongoing arbitration proceedings saying they are not complying not only with the order.
Then what happened?
Lordship, just grant me 1 minute, my lord. In fact,
tell us what happened in that.
So what they do is, pending, they siphon off 4.3.
This I take strong objections.
Let's give them a.
No, my lord, because they have.
Yes, please. Let him have
it. Just 2 minutes, my lord, I'll be able to sum up. Pending the arbitration, when they were not paying an application for appointment of a receiver. 4.3 crore rupees, and I'll be able to show it from the right side. After 4.3 crore, they withdraw their claim from the arbitration. I file a counter claim that partnership at will. The arbitrator says no, is withdrawing, it's left open for you to work out. I then issue a dissolution notice. Section 9 court asking for appointment. Receiver appointed. What your lordships are hearing today is not order becomes final. The court records it's a partnership at will. The arbitration award did not make it a continuing partnership. One of the partners can dissolve it. Dissolved, therefore it's at will. If it's dissolved, receiver ought to be normally appointed. They said it must be the person who's conducting the business. The trial court was sensitive to appoint them as the receiver. For a period of 6 months, they play ducks and drakes with the court. Contempt case filed by us. Now what happens is, in the meantime, we file an appeal before the High Court saying that they are not discharging their duties properly. They are conducting the business insidiously. But before the High Court, they consent. But first, appointment of receiver not challenged. Before the High Court under interim order.
What? They consent to what?
Consent saying that yes, let a neutral person, a retired district judge be appointed. So a retired district judge consent, my lord, by the High Court. After the retired district judge is appointed and the district judge goes to take charge, since these persons have been conducting the business, they make all 100 employees not report to duty. They want to frustrate the district judge. The district judge has submitted a report before the High Court. If a lordship were to summon the seal cover, the seal cover will show how they systematically try to frustrate the appointment of a receiver to which they consented. Then High Court in this final hearing takes a decision that they have not been conducting the business fairly. They are guilty of, the court does not record a finding, but I'll be able to show to your lordship that 4.3 crores has been diverted. Before the trial court, they say, yes, we diverted.
Now that we got the overall, we're just trying to find some business-like solution to the matter, not an IRP.
Correct.
Tell us one thing. You live in Bangalore.
Yes.
Are you willing to be a receiver?
Hyderabad. We live in Hyderabad.
Can you act as a receiver?
They would say that I have not had prior experience, but I'm fully willing to act as a receiver. Your lordships can assist us also, and we will fairly report everything to the court.
On the other hand, look,
yes,
we are also conscious of the fact that they are 86%, you are 14%. Suppose, for instance, we are not finding suppose we give them an opportunity to act as the agents of the receiver, subject to stringent safeguards that we appoint, say, a chartered accountant, all right? A chartered accountant or a retired judge, preferably a chartered accountant both of you have faith in. Scrutinize the accounts which are prepared by them on a weekly basis, fortnightly basis, whatever you feel is appropriate, to ensure that they don't siphon off any funds from here and they duly account for whatever is being. Looking at it is, look, you have given a dissolution notice, there has to be a lock on the door. But that I'm not sure if it will protect both your interests.
But I respectfully agree. I may just make one or two submissions. What happens now, my lord, if it has to go up towards resolution, the partner can buy out the other partner, there's no difficulty. My lord, the real, my lord, crux will arise.
Tell us one
thing.
1 second. Tell us one thing. We can try and put an end to it. Suppose we say they're 86%. There are 3 brothers and 1 sister on one side. You have 1 sister on the other side. No point in your fighting for the next 10 years on this and your happiness on this. What if we say that, look, we will give them the first opportunity to buy you out, right? Do both tell us the name of a valuer. If you want a retired judge, we can name a retired judge. Ideally, you tell us the name of a valuer, a chartered accountant, in which both of you have confidence, right? In which case, that chartered accountant they'll value the business, the assets, the goodwill. On that basis, quantify your 14% after excluding if there are any tax liabilities. And they will buy you out at that. If they don't buy you out and pay money within, say, 14 days of the determination, you buy them out, an opportunity to you to buy them out.
Yes, two submissions, my lord, because what would happen, my lord, if they would have, it might work to my disadvantage. I'm only placing it for lordship.
Already, the other way you can do. Once the valuation is done, you give bids and steel cover, and whoever gives a higher bid will get the place if you want it that way.
Submission, but this is a difficulty a value. My lord, I quite see, my lord, why your lordships are completely respectfully agree. But
Any
just one
other
submission.
you are both people of business. You tell us, we'll adopt it. We have no difficulty.
Totally with your lordship.
But one difficulty.
One of honestly, my lord, this is a business which is a flourishing business. The sad part is someone from the panel of IRP has been appointed in a flourishing business. We are 86%. Any fair price we'll buy.
What we can do is,
Yes, ma'am.
suppose we appoint a valuer.
Please.
Who will value the business assets, good and then decide the.
May make one
In the
submission.
meantime, just a second. You don't want the restaurant to be closed.
Correct.
We can allow them to run the restaurant in the meantime. Safeguard that they will submit accounts to the chartered.
I have.
Yes.
So only to take what fell from this honorable court further. My lord, I'm not
Right.
contradicting it. My lord, what will happen is there are two important components of this business that need to be valued. One is, my lord, the immovable property, easy job. They'll be able to value it. The other is the goodwill of the business, my lord, because this particular restaurant generates a huge amount of money and mostly in cash. So what happens is, my lord, if a person is kept outside, my lord, the goodwill valuation comes down. My lord, I'm making one respectful submission of your lordship's consideration without prejudice.
Is there a bar or
There's no bar.
there's no bar?
Yeah. But my lord, it's one of the most famous.
But it's famous for its biryani.
I go to Hyderabad.
The
I eat
biryani, it's famous for its biryani, which neither my lord, the Chief Justice, nor I have any idea of. but it's
But if any of my other lords, my lord, are partaking non-vegetarian food, I must strongly recommend that this biryani your lordship should.
Unfortunately, this IRP also claims to be a vegetarian.
One submission.
Who's asked to run it?
Just for ensuring, my lord, accounting of the money that is coming, the restaurant has to open, my lord, I cannot object against that. Lord, I am suggesting, lordships may kindly appoint joint receiver. One will be, my lord, them conducting the business as. I'm therefore making a submission, my lord, that may find.
Tell us what is the suggestion.
My lord, if a joint receiver is to be appointed, which is, my lord, any one person that your lordships may appoint, RP, any other person, my lord, as the receiver, them as the other receiver. What happens, my lord, is then every rupee, every money that comes in will be accounted. They can't have an objection to your lordship who will conduct it jointly with them as a receiver. Earlier, when they are appointed as the sole receiver, my lord, they have actions to show that they were not reporting fairly. Now, this would mean, my lord, that the valuations would come.
For the tax returns, the net income shown.
Net income?
30 crores a year.
30 crores a year.
In excess of 30 crores.
Crores.
Turnover is 30 crores.
Turnover.
Net income, how
Just one standalone restaurant.
It's just one restaurant.
It's not a chain.
And my lords, it's
Just
a,
one.
it's a,
It's
it's a very
standard.
quaint cafe, my lords. It's the
I am told. But
wooden
I am
chairs.
told.
It's
But I am
that
told.
kind of cafe.
These figures are on
Majority of the
record.
returns
for
that
the
are
trial.
filed are in relation to.
My lords, they must
are
also
alleged.
say 25 lakhs is their share.
But whatever
2 years
is the-
ago, they've taken out 1 crore and 25.
But
The other
whatever is reported, not subject to further proof, I'll be able to place for your lordships. There is an underreporting of income because whatever is QR code scanned, UPI payments, whatever are Swiggy deliveries constitute the majority of the accounted sales.
we appoint you as a receiver?
All the cash.
How much will you be willing to deposit
Deposit is security.
On a monthly basis.
Security.
on a monthly basis?
2 crores. Well, it will matter valuation be done. Meantime, we'll deposit 2 crores as security.
A month.
They don't have
A
2
month.
crores a month. 2 crores will deposit. Let the valuation be done within 4 weeks or 8 weeks, and we can conclude the matter. We're saying here and now, whatever value or whoever
We
your
will
lordship
deposit 2
appoint,
crores, 10 lakhs, my lord, and permit us to act as a receiver. If that is what they say. They should be fair to your lordships.
Was
Lord, I'm
never
making a
run
very,
the restaurant.
making a very fair suggestion.
I think they should be asked to deposit.
May make one.
Tell us, you give us a ballpark figure.
I arrived at 2 crores based on 30 crores. I
He
just
just put
arrived.
2 crores, just like
May make one.
people were saying 2 crores per month.
No, he misunderstood
Small
that money. This is a place, my lords, in Hyderabad town itself, township, there's a little
tell us,
restaurant.
what is fair.
No, my
You
lord,
tell us.
my lord, my lord,
Give us a ballpark figure now. Whose time here? We'll pass an order right away.
instruction because the clients are not here. But just one submission if it appeals to my lords. But we want
You are saying joint receiver.
yes.
My
You got
lord, won't work, my lords. How are we
So
to
they
run
will
if
run the
they...
business.
The problem is, one receiver, close the second receiver says, I
This.
Let them
We
run the
will,
business.
we will not ask you or we will not ask them how much security they should furnish.
Correct.
We'll fix the security. Once we fix the security for them to run as a receiver, instead of a joint receiver, what we'll do is we will appoint a chartered accountant whom they will submit weekly accounts.
Daily, it's cash. Mostly is cash. There are many times that I have paid in cash.
That chartered accountant will lose his own practice if we ask him to do it there.
The only thing is this, my lord, because which is why.
Accountant will have to depute somebody.
Yes, my lord. And your lordships may willing to bear half the cost. Lordships may fix some reasonable remuneration. Let somebody be there. Let them completely be understanding what the accounts are. Let them run the
there's
business.
no allegation that cash
Okay,
is
do you
taken.
both
This
have
is-
any,
see,
do you have any faith in a chartered accountant joint name you can give us?
Malas, a chartered accountant to take our accounts even on a daily basis,
Yeah.
we have no problem.
Fair enough, but can you both not give us, at least as counsel, give us the name of a chartered accountant in Hyderabad?
I can
Who's
sit
a
with
good
them and give some names.
Just tell us right.
Who's a good chartered accountant? Anyone, you name them. Who's your chartered accountant? He says he uses
Only one.
that's his.
Lord, there are 2 or 3.
Lord, may I say
Between us,
this?
we'll be able to give
This
a name.
statement of money being taken out and cash made for the first time orally before your lordships. This has not been their quarrel. Their quarrel was I took out 3 crores and it's been recorded that they got their share of 1.25 crores at the same time.
Contempt
At the same time, we both took out shares from the partnership.
The contempt case filed specifically as acted as receiver. This is what they have done. Lord, for full the receiver directly to the court. That's a contempt case filed.
Notice issued.
Notice issued, sir.
Restaurant non-fungible. Doesn't help.
Malats, and if anything, they have 14%.
2 people have tried to run it.
Record your terms, they will record terms to the effect, all of you, you will, there will be a valuer appointed,
Malats.
all right, to value their 14% share, all right. After the valuer values the share, you have the first right of refusal them that their valuation and pay it with weeks. Paying it, they will give you that offer for your 86. Can you record these terms and come back by the evening today by 3:30?
My lord may make it an order of court by consent. My lords may make it an order of court by consent.
Yes.
Even for the valuer to value, need to know the income. Lord, the income. Lord, if there is a joint receiver, I'm saying let some other person be there.
Valuer is still the
just bear with me. But I'm making a submission which they cannot have an
valuation. Is valuation.
Let them run the business. Let some firm, my lord, look at that business. After 1 month, my lord, value.
Understand who's a part. Be quite a. Who was originally from Hyderabad. Because he'll value it as on today. I run it, I'll deposit an amount.
Or what we'll do is we'll dictate the order. Guys, give us either by name of a chartered accountant.
Any name your lordships are.
We don't know, because neither of us belongs to Hyderabad. We just took the name of Mr. Lokesh Gupta. If it's acceptable to you.
In Hyderabad or in Bombay?
He is in Bombay, but
Then no, give me someone. Agarwal is the name.
Get somebody from Hyderabad.
Hyderabad. His own.
Otherwise, then we'll have to ask one of our colleagues from Hyderabad to give us a name.
One of our colleagues from Hyderabad, Malats, would be Hyderabad.
So we will just see if this is agreeable. We'll dictate the order. The petitioners, the dispute in the present case relates to the affairs of a partnership firm which is conducting the name of Cafe, Bahar and Restaurant in Hyderabad since 1990.
1970. 73.
Don't say since, just say in Hyderabad. Full stop. The firm was reconstituted by a deed dated 1 October 2020, correct?
Correct.
Full stop. The first respondent, full stop. How many petitioners? You said 4.
4.
The 4 petitioners, into brackets, comprising of 3 brothers
And 2 sisters.
comprising of 2 brothers and 2 sisters, bracket, and the respondent, siblings. Full stop. The petitioners have an 86% share in the profits.
In the firm, in the partnership firm.
They have an 86% share in the partnership. Full stop. The respondent has a 14% share. Full stop. Is it respondent or first respondent?
Sole respondent. Sole respondent.
It says and others, that's why.
Oh, sorry. Mine doesn't.
Sole respondent.
Sole respondent. I'll just check it. 22.
Initially, the petitioners,
Yes.
petitioners 1 to 3, initiated arbitration proceedings for dissolution. Their arbitration proceedings were for dissolution. And for dissolution and accounts?
Yes, ma'am.
For dissolution and accounts. The arbitrator passed an award on 22 September 2023, permitting the withdrawal of the claims. Full stop. The first respondent issued a notice calling upon the petitioners to render accounts and for distribution of the assets of the firm. Full stop. An application was filed under Section 9 of the Arbitration and Conciliation Act for the appointment of a receiver. Full stop. The application was allowed and a receiver has been appointed.
Correct. By subsequent order, receiver appointed.
Yeah, the application was allowed. Full stop. The commercial court passed an order in the first instance by which the first petitioner, who is the managing partner of the firm, was appointed as receiver. Full stop. In an appeal under Section 37 of the Arbitration and Conciliation Act 1996, the High Court set aside the order of the commercial court and has directed Shri Dantu Indu Shekhar, right? Dantu Indu Shekhar, resolution professional in the Insolvency and Bankruptcy Board of India,
That's correct.
to be appointed as receiver to manage the affairs of the firm.
Who has since filed a memo saying he cannot do it.
That's all right.
Yes.
The court has been apprised of the fact that the receiver, that the person appointed as a receiver has since expressed his unwillingness to, correct?
Because of
Unwillingness to act as such. At this stage, it is an admitted position before the court that while the petitioners have an 86% share in the partnership, the first respondent has a 14% share. Full stop. The Mr. Aryama Sundaram and Mr. Sibal, appearing on behalf of the petitioners on the one hand, we have heard learned senior counsel on both the sides. Just 1 second. Don't lose sight of the order in case there's something you have to correct us. Learned senior counsel appearing on behalf are fairly agreed that the affairs of the restaurant, that the proper conduct of the affairs of the restaurant would not be subserved by appointing someone unrelated to the business as a receiver, because that may only result in a loss of the goodwill of the business. Correct? Can we say that? Or don't say learned counsel apna kar do. That is, I think, it's common sense actually. So, hence, during the course of the hearing, we have suggested, during the course of the hearing, it has been agreed that in order to resolve the dispute between the parties finally, a valuer may be appointed so that the business of the partnership can be valued inclusive of its assets, goodwill, and assets of all nature, or inclusive of all assets, goodwill, and the liabilities. Stop. Once the net valuation is arrived at, it has been agreed that the petitioners shall have the first right of refusal and offer to the first respondent an amount equivalent to her share of 14% in the partnership within a period of 2 weeks of the date of valuation. Full stop. In the event that the petitioners fail to do so, then the first respondent would be at liberty, would have the right to purchase the 86% share of the petitioners on the basis of the valuation fixed by the common valuer, by the valuer. Full stop. To effectuate the above purpose, the work of valuation shall stand entrusted to anybody's name.
Who's valuer?
But we'll give some leading names, but I'll just.
All right.
Either and company.
Why don't you do this? Both of you.
I think both of us should.
As senior counsel, you give us one name. Don't look at the client. Give us one name. Mr. So and so, Mrs. So and so shall stand appointed as valuers for that purpose. Then next you say, pending the requested to carry out the work of valuation expeditiously and within and on or before 31 December. 31 December. Full stop. Next, pending the permitted to resume the business of the rest. Full stop. The now the arbitrator is already appointed.
No, my lord.
Appointed, but if, my lords, the matter is going to be sorted out by the valuation, it need never go to arbitration. The whole matter is
One
over.
request.
So we were thinking that we can implement this order.
Yes.
Very well.
But in fact, your lordship.
My lord, earlier your lordships had appointed. Not.
Should we appoint Justice Raghuram?
Praveen Kumar.
Yes. Absolutely.
Yeah, Mr. Sudham will appoint Justice G. Raghuram. By consent of the parties, Mr. Justice Goda Raghuram,
Yes.
former judge of the High Court of Andhra Pradesh, is appointed as sole arbitrator under the Arbitration and Conciliation Act 1996. To stop. Initially, in the event that the parties are able to settle the dispute in the terms indicated above, it would not be necessary with the arbitration. However, parties would be at liberty to apply before the arbitrator for giving effect to the terms have been agreed upon in court, so that a final award can be passed for implementing the understanding. Right. So because we don't want it to come back.
Right away, Justice Raghuraman is also vegetarian.
two submissions. My
Yes.
Lordships are completed. I'm sorry. But one, Lordships are appointing a valuer. Let the I'm sorry. Let the valuer have an active evaluation of the accounts, because anyway he has to. It will only help. But second thing.
What do you mean by active valuation of the
Which means, but I'm only suggesting that all the monies that are received on a day-to-day basis can.
The petitioners shall maintain accounts and shall furnish weekly accounts to the valuer so as to facilitate the work of
Valuation.
Right?
My lords, please.
My lord, I am only reiterating my request, my lord. If somebody from the valuer's team can be there to look at the accounts,
the valuers would be at liberty to depute anyone associated with their firm to the premise restaurant so as to take a daily stock of the accounts of the firm.
I'm grateful.
My lords, please.
That's
Lordship.
My lord, one last caveat, my lord, subject to what your lordships would say.
now what we'll do is I'll ask master to type the order.
Yes.
To give you both a printout. Since we have dictated it as a consent order,
Yes.
any change you want, just come back at 3:30.
But only one.
If anyone would like to just come here, or you can call them to the courtmaster's room, or wherever. What will you do? You should ask, like anybody to go to the courtmaster's room, he'll show you the order on the screen. Any correction or anything, just tell us at 3:30.
Yes.
Otherwise, then IAs, MAs, this and that,
But only one request. Yeah. My lord, once the valuation comes, your lordships, my lord, because they are 86%, they have been given the first right of purchasing, your no difficulty. But suppose to pay a higher valuation and ready to buy them, it should not be that the valuation should be binding on me.
Well, it can't be 80. It's
No,
not
no,
fair, my lords, that
I
we get
take
into a
higher
bidding
offer.
warfare. Because I don't want them to bring in a third party.
My lord, it has to be
He
fair
can't
to both.
then start bringing in a third. That will ruin the whole thing. It's been a family business.
Let's
My
suppose
lords, if he
it's
goes into
valued
this
at-
warfare of that, then he brings in a third party.
Let's
Whereas
suppose-
it's a family business. We're proud.
If it is valued at 100 crores, I will say
Well,
I
it's
will give
business.
150 crores and pay 86% on 150 crores.
It's a family business.
which I have managed since the age of 14.
I think it's a family business. Let the business stay in the family. What will happen is,
That's it.
suppose we start bidding, then some third party will
Yes,
take
It's
over.
between us.
It's
my lord.
not, it's not really in that sense desirable that a third party comes in.
Exactly.
It's a business which is run by the parents.
And my lords, to
To
the
the
extent,
death of the parents, both of you have run it.
and the extent that the recipe is only known to the members of the family. That's why we don't have franchising.
My lord,
We haven't even given the franchising to anyone.
my lord, my submission was between us, there should be valuation.
From the time he's 14,
It
he's
should
not
not be-
running this business.
In fact, we thought that your suggestions is attractive. The only problem is if we allow bidding, then we say, for instance, your client. Suppose your client is financed by somebody else who says, look, we'll match their offer and we'll give a much higher, then the restaurant will go out of the family. It's better that the restaurant stays in the family. I mean, we're not looking at it in a commercial sense, but in the family, it's a family restaurant. It's in the family for such a long time. So either if they don't buy you out within, giving them a long rope, 2 weeks for the valuation,
But please
then
look
you
at
buy them out at 86.
My lord, please look at one concern.
Yeah.
One concern. My lord, if the history, my lord, and your lordships are very lordships can take judicial notice. My lord, in many of these unorganized businesses, my lord, what happens is a lot of cash income is not reported.
Obviously, it's all cash.
Yes,
The
lordships are
restaurant,
there.
yes.
Now, what happens? Valuations are to be made on these historical accounts that have been filed. The valuation will obviously be lower than the valuation the business actually deserves. Then what happens if the value?
What
They will say
do
we'll
is,
pay you
we
7
will say
crores
the
and
current
sue you.
value. We'll say the current value, and we have said that he will look at the accounts on a daily basis to see what the generation is.
Yes.
But at least if your lordships could enter those caveats.
We'll just say that. Valuation, bolo. Just have a look at the order in the courtmaster's room. If there's any correction, come back at 3:30.
My lords.
One
And
final,
we'll just try to bring some peace, otherwise they'll just fall.
Lord,
They'll fight for the next 10 years and the business will get wiped out.
yes. One final request. But even when they were appointed as receiver by the trial court, but there are a set of conditions that were imposed. They are there in the order, which I'll give the page number, my lord.
The
Even
petitioner
the-
shall abide by all the conditions
Which
that
the
have been
trial court
imposed
had.
by the trial court.
Certainly.
for the appointment of in connection with the appointment of the receiver.
My lord.
So I'm depositing 5 crore in addition.
In addition, so that we don't come back with a clarification petition for your lordships.
The amount of rupees, ऊपर लिखा था ना, 5 crores. The amount of rupees 5 crores shall be deposited within we have said within a period of 1
Your
week.
lordship said 2.5 crores in 1 week,
1 week.
and 2.5 crores in 4 weeks.
Yeah. Within, वो बता दिया ना, लिखा ना आपने, before the High Court of Telangana.
My lords, please.
My lord, in relation to this, I'm just total amount lying in the partnership account was 7 crores. They have taken 4.3 crores. 3 crores is in the partnership account. This amount should not come from the partnership. It cannot be partnership money.
The amount of rupees 5 crores shall be deposited, shall not be taken from the partnership account by the first petitioner from his own funds, because not from the partnership account.
Only to save, my lord, any
Petitioners.
Petitioners.
4 petitioners.
Fair enough.
only to save us coming back to your lordships for any smaller issues. Lordships may kindly grant the liberty, my lord, that if in the working out of this order, if we have any difficulties, we can approach the arbitrator appointed by lordship.
There.
Yeah.
I'm hoping by 31st December it will
The event,
all be over.
any difficulties arise in the implementation of the present order, or if any consequential directions are required to be issued, parties would be at liberty to move the arbitrator. The learned sole arbitrator would be at liberty to issue directions under Section 17 of the Arbitration and Conciliation Act 1996.
My lords.
But everybody doesn't have to run to the Supreme Court. That's a fair suggestion.
Yes.
This is a fair, balanced order, I think. You
Please,
can
ma'am.
get the restaurant, but you have to.
Name, I think my lord might know, my lord, I'm suggesting Anandam and Company, which is a leading firm in Chennai and Hyderabad. I don't know the names. They're
Give
not
me-
my chartered account.
Give me 5 minutes.
Anandam and Company.
I'll just check it out, my lords, whether
And
they.
just let us know so that there's a court
I
martial.
shall. I'll just. My lords. Who's Anandam?
Please, my lords. Item 10, the petitioner is seeking admission under the sports category for medical seats in Karnataka. Similarly,
Dated 16th March, and it will be notified by KEA on his website before the last date for submission of the application.
please, my lord, that it was notified on 16th of March. The important aspect is my applications for
First round commenced on 1 September, second round on 18 September.
and my lords on 11th September.
That was too late, because after the second round was started, it is only at the stage of mop-up round of counselling that petitioner approached the High
That
Court.
finding, my lord, with my humble submission is incorrect. The first round had indeed concluded. Before the second round had started, I had filed my writ.
The amendment was done in March.
But the seats were still vacant, my lords. And there was an interim order also passed in my favor. One seat was specifically kept aside, my lords.
11.
My lords, in item 11, I appear for the state. The matter was mentioned day before yesterday. I had made this request, my lords. Notice is on 2110. I need time to file a counter, my lords. It's a commercial dispute, my lords.
All right, let him file
My
it.
lords, no, there was a reason why I had in fact mentioned day before yesterday, my lords. We had moved an application. Now, what had happened was for 2 years, the arbitration went on.
His review petition allowed, is it?
Yes,
On
ma'am.
4th of October,
Recalling
by
the-
9th, they went ahead and took unfair advantage. I had a section 17 protection for BG. They went ahead despite my informing for BG. I've already filed the SLP. They encashed the BG.
They went for?
Whereas they went for encashment of BG, though I had informed SLP has already been filed. My interim relief was encashment. Now, my lords, I know this is a different predicament, but my submission is this, my lords.
My lord, the BGs have
Well,
been cashed
my-
on 910. Now they seek
Correct.
mandatory injunction.
9th is when I had filed the SLP.
First are from
The problem is this,
20.
I wouldn't have trouble. The problem is this, my lords. I have a loan of 32 crores. This is a 15 crore BG, which they have now taken from my bank account. It is already gone. This is bound to go NP. I'm running real estate projects there. The entire thing will go for NP. I would not live to fight for on the day. So my submission, my lords, for lordship's consideration, I'm willing to revive the BG provided they give me the money. They'll be fully secured with the BG anyway. It is not that they're not secured. So, my lords, I would give the BG, let them deposit that amount. I'll take it and again give the BG back. The BG was alive till January 25. They were fully secured. There was no reason to immediately state for within 4 days of the order to encash the BG. So anyway, they'll be secured, my lords. There'll no prejudice cost. I am seriously prejudiced today. Today, if I go to NTA...
The High Court says that since only the engineer-in-chief could be an arbitrator,
Yes, my lords.
Therefore, says there can't be any arbitration because he's disqualified.
At all, my lords.
But therefore, they gave you liberty to move the civil court. That's
what had happened. So what happened was on the first day of Section 11, they did not object for the first day before the learned arbitrator.
And just Hemant Gupta.
Yes. Before the learned arbitrator also, they gave their consent to proceed. They filed a counter claim. The evidence is towards the end. And now at this stage, they reversed. And 17 in my favor. They never challenged the 17 order. There was a BG encashment protection in my favor.
Ultimately, just 2 former judges of our court have been appointed as arbitrators.
No, my lords, so there are...
What is the stage of the evidence?
So, my lords, evidence had commenced. The facts have been concealed from this court are that when the review petitions were filed, an undertaking was given by the petitioner that they will not further the matters before the arbitration. That undertaking was breached. 5th of January 2024, a stay order is passed. All this is concealed in these proceedings.
Where?
Before the High Court, my lords, both the arbitration proceedings. On 5th January 24, it is concealed. Now the order of 4/10/2024 is passed, recalling the orders of arbitrators on the ground, my lords, that 1, the arbitration clause did not exist as it is worded. 2 and 3, my lords, that there is no section 20.
So 2 and 3 what?
There is no section 21 notice, my lords. It's an admitted position. And my lords, I'll take my lords to that.
They never gave a section 21.
It never gave it, and it is admitted, my lords. And they say, my lords, in their reply to the civil review that they filed before the High Court, that the order was out inside chambers, my lords, not in open court, and it is a copy-pasted order. And we don't agree to the submissions recorded on our part in that order. It's very strange, my lords, and therefore these documents on record. And there is absolutely no prejudice. What my learned friend has said about the loan, etc., none of it is pleaded.
The prejudice is really of... But the state would have no prejudice at all in case just my BG is revived. Today, my lords, I'm likely to go for NPA. There's a serious problem I'm already facing. I've already defaulted in my first month. My lords, eventually it will go for NPA, my lords. I am running a real estate building of 1,000 allottees. That will also go in NPA. How is state prejudice today just restored, my lords? That is all I'm asking for. They are fully secured.
Huge relief because they've encashed the guarantee, Mr. Baruka.
But within those 4 days, 4th of October is the High Court order. 9th letter. The moment I write a letter, they immediately encash. In my interim relief before SLP, my lords, I have written kindly grant me stay for encashment. So it was when I filed the SLP, BG was not encashed. It was encashed the moment they got to know SLP has been filed. There was no hurry. The BGs are 25. Even today also, my lords, I'll maintain the same terms conditions. My lords, the only problem is today I will go on NPA. My creditors, the bank loan, etc., they will initiate NCLT proceedings against me. The other real estate that will then go down with those 1,000 allottees. State would have no trouble if there is another BG in cash securing them.
None of these
that is my only concern today, my lords.
None of these facts are pleaded and shown to show any.
You know, the High Court has reversed the order for valid reasons. Actually.
Yes, my lords.
High Court has reversed. The Honorable High Court has reversed without realizing that specific consent arbitrator that we have no objection in the appointment. There is a specific, my lords, kindly just see page 469. And they filed a counterclaim, my lords, of 350 crores. 69, my lords, may I just read 3 lines of 469? The first procedural order of the learned arbitrator, page 469. And I leave at it, my lords.
Yes.
There is a consent. Kindly see above paragraph 3. Both the parties as well as their counsel stated that they have no objection towards my appointment as the sole arbitrator of to act as arbitrator as ordered by Honorable Patna High Court by order dated 1/2/2023. After that, they filed a counterclaim of 350 crores. At the respondent stage cross-examination, my evidence is over. And then at this stage, my lords, the Honorable High Court, in a review petition, reviews Section 11 order and recalls the order. In fact, my lords, in my submission, my lords, that will another question of law will arise whether review petitions at all maintainable in Section 11. But at this present stage, my lords, just to safeguard myself and also equally safeguard the state, the bank guarantee can be restored. The amount can be given back. I will immediately restore the bank guarantee. They are fully secured. Tomorrow, if they succeed in the arbitration, they have the bank guarantee anyway. How is prejudice in that matter, my lords?
My lords,
Today,
no
I'll be
fact-
seriously prejudiced, my lords. If today the NPA goes, I would not live to fight this matter.
My lords, no
For
fact.
2 years, there was a Section 17 protection in my favor.
Even invoked arbitration. There was no section.
21, my lords, and there's a stay by the High Court in the review.
I think not a case. for
That is concealed. I'm grateful. My lords, liberty to file a counter, my lords.
Where?
File a counter, my lord.
Yeah.
Oh, I'm sorry, my lord, dismiss them.
Yes.
I'm so sorry, my lord. I'm so sorry.
Lordship.
Grateful, my
Please, Your Lordship.
Yes.
Item 12 minutes, I am for commission, IPLM.
Yes.
Item 12.1 is another appeal. 12.2 is another appeal. So, my lords, is appeal against April's order,
Yes.
whereby, my lords, at the truing up stage, we denied the claim of erstwhile R infra, my lords. Is R1 in the appeal. Now probably they have moved an application for their deletion. R2, sorry.
R1 is without.
R2, sorry.
R1 is without.
AIPL, yes, yes. I stand corrected. R2, my lords. 2 and R1,
How long will this matter take?
it will
There
need
is,
some
according
time.
to us, no substantial question of law. That's what the Lordship
My lords, on that I can answer, my lords.
Take?
My lords, if it has to be, I mean, he is raising a preliminary objection. If about 10-15 minutes.
How long would you take on apart from the preliminary objection? What is the preliminary objection, Mr.
That there is no substantial question of law under Section 125. Because the tariff has been, it's a tariff determination, my lord. All that the tribunal has done is, I got cost for unit 2. For unit 1, I have been given same as unit, for what was given for unit 2 has been given for unit 1. And the finding is
Fuel costs.
landed fuel cost. It's actually, my lord, in terms of the regulation. I am only asking for what is as per the regulation. They have tried.
What do you have to say, Mr. Runka?
On this.
My lords, yes. On question of law, my lords,
Yes. What's
there
the
are
question
3
of law?
substantial questions of law.
Yes.
1.
Tell us just one.
So the first is this, that whether at the truing up stage, we can give a go-by to the principles of tariff, not only provisional, but final tariff. That is the first question of law. In this case, my lords, the final tariff was determined. Provisional tariff was determined. Then final tariff was determined on their application on the basis of their own projections, my lords. Now at the stage of truing up, my lords, they have come up.
Take a little time.
May I just make a submission?
I only say 2 things. Of course, my contention is that all along, my lords, we have gone under the tariff regulation. They say it is changing of the methodology. Their own order said that it will be under the regulation. You will get fuel cost as per regulation 49. That's all I've got. That's all that the tribunal has fashioned that relief. And the finding of fact in my favor is that the not getting that fuel supply agreement is not on account of any fault of mine. I had gone right up till the end, till the very last stage, and the government didn't give it to me. It's not my fault. On account of the amendment of the coal development policy. So, and additionally, up till that stage, they approved the PPAs. So